Good afternoon. Good afternoon in India and in Bhutan, and as well good morning in the Netherlands. My name is Aurélien Lorange, and together with my colleagues in the Corax Foundation, Mr. Banova and Mr. Sanchez, we'll have today a match with two teams who are starting the competition. These two teams are in the Group A. This is the day one of the Inter-University Law Debate Tournament group phase. So today we'll have Jigme Singye Wanchuk School of Law from Bhutan. This is their first participation, even first participation from Bhutan, and as well Jindal Global University in India. So these two universities received the topic 1 week ago, and this topic actually they have been preparing both sides, and today we'll know of course which positions they will have and as well their own debate. But before going to the debate, let's start with knowing our debaters today. So I will ask Miss Sonam Yingyaong Laden to introduce herself. Welcome. Welcome, yes.
Welcome, yes.
And you,
Hello, am I audible?
yes.
Yes.
Hello, my name is Sonam Yugyong Hatin, and I am a third-year student at the JSW School of Law, and I am 20 years old as of now, and I'm very excited for this opening match today.
Thank you. Welcome.
Thank you.
And we have as well on the side of Jindal Global University, Sai Prasad Sriharsh. Welcome.
Hello, am I audible?
Yes, you are.
Yes, thank you so much, sir, for this opportunity to perform on this platform. I am Sai Prasad Sriharsh. I'm representing Jindal Global Law School. I'm currently doing my fourth year in the law school, and on behalf of myself and my teammates, I look forward to this competition and all the very best to the opponent team as well. Thank you.
Thank you and welcome. And we have as well in Bhutan, Eiden Dima. Welcome.
Hello, Hello, am I audible?
Yes, you are audible.
Hello, everyone. I am Yuten Dema, and as of now, I am 20 years old. I am a third-year law student at the Jimsing Yongchu School of Law. Thank you very much for this amazing opportunity and for letting our school participate for the first time. We look forward to a very fair and amazing match ahead.
Thank you and you are welcome. We have now as well at Jindal Global University, Sarah Bhargava. Welcome.
Good afternoon, everyone. I hope I'm audible.
Yes, you are audible.
Yes, I'm Sara Bhargav. I'm currently in my third year of the law school, and I'm pursuing my law from Jindal Global Law School in India. And I'm thoroughly excited for the match ahead.
Thank you.
Thank you.
Welcome. And we have the third member for the team from Bhutan, Kinley Yangdon. Welcome.
Hello everyone, my name is Kile Youngdon and I'm 20 years old and I am a second year law student here at JSW School of Law. We are really grateful for this wonderful opportunity and we are looking forward to a wonderful match. Thank you.
Thank you. Welcome. And in Jindal Global University, the third member, Ms. Orshia Sarkar. Welcome.
Hello, I am Orsha Sarkar. Thank you to the organizers for organizing this debate. And I am from Jindal Global Law School. I am in my third year. And all the very best to my opponents. I'm sure it will be a very fruitful debate.
Thank you. Welcome. So now, no, not now. First, we want to greet as well the coach. We have on the side of Jindal Global University, sorry, Ishraj Iyer, who participated last year. Can you hear us, Mr. Ear?
Hello, I can hear you. Can you hear me as well?
Yes, as well.
A very good morning to everybody at the Netherlands and a very good afternoon to my team and to my respectful opponents at JSW Law School. I'm very happy to be the coach of the team representing Jindal for this year. And I'm very thankful for the organizers to conduct this entire event as well. I wish both teams have a debate and I look forward to it. Thank you so much.
Thank you very much. Good to see you. And as well, the second coach, Namrat Amadou Ragunat. So I don't know if you can hear us, but we send greetings to you. Yes?
Hear me?
Yes?
Hello.
Yes.
Um, First of all, I'm really glad to be here, and congratulations to both teams from both the law schools. I hope both the teams have a very fruitful debate, and we all get to learn something from this. So all the best, and we both look forward to the debate.
Thank you very much. On the side of JSW School of Law in Bhutan, greetings as well to Leki Chering. Leki, can you hear me?
Hello, am I audible?
Yes, you are.
Hi everyone, my name is Leiki, and sorry I have my camera off because I'm here currently in the United States and it's 1 a.m. right now, and the connection seems unstable right now, so I have to keep my camera off. But I wish both teams all the best. I know you all would have prepared well, so just giving your best, and we look forward to watching this amazing match. Thank you.
Thank you very much. I believe you are in Denver currently. So thank you for connecting in middle of the night. And as well, thanks to the two other coach, Pemal Shoki and Ashish Gurung, who has been coaching, who will be coaching for this world competition. And we send greetings as well to the three judges. So now it is time to do the allocation of position. So you will know which position you will have during the match. My colleague is sharing the screen. I hope you can hear, and you can see, sorry, the wheel with the two institutions' double flags. So there are two positions possible for each team, to be in favor of the motion or to be against the motion. So now we'll see which position you will have during the match live. And the team will be in favor, will be starting the match with the first introduction. So for this match, that will be OP Jindal Global University will be in favor of the motion, and will be starting the match with the first introduction. And as a consequence, Jing Mesingye Wonchuk School of Law will be against the motion. And to concretely clarify, OP Jindal Global University will defend the position that national intellectual property regime should operate in accordance with international cooperation obligations. In the meanwhile, the team from Bhutan will defend the position that national intellectual property regime should not operate in accordance with international cooperation obligations. Now you have 5 minutes to review your notes, and then we'll hear the introduction by OP Jindal Global University.
Thank you, everyone. The time for final preparation has now passed. We'll be starting by hearing the opening statements for today's debate by the team in favor. Therefore, OP Jindal Global University team, you have 4 minutes.
Good afternoon, respected members of the House and my esteemed opponents. Am I audible?
You are.
Okay, so I will begin at the reverse countdown of 3, 2, 1. Today, this House debates a motion that sits at the very heart of modern governance: whether national intellectual property regimes should operate in accordance with international cooperation obligations. The proposition stands firmly and proudly in favor of this motion. Our case rests on a single principle: that in a world where innovation, medicine, technology all cross borders seamlessly, the rules that govern them must too. IP is no longer a matter of domestic bookkeeping. It is a global public good and has global public consequences. Cooperation is not idealism. It is legal, logical, and the only moral response to the reality of our interdependent world. We will establish this through three contentions. Our first contention being the globalization of technology requires globalization of regulation. A patent that is granted in Washington, which decides that medicines need to be affordable in Nairobi. A copyright rule enacted in Brussels determines what content creators in Mumbai can legally share. IP does not respect borders, and a legal regime that pretends that it does will systematically generate more cross border harm. Countries that implemented US FTA data exclusivity provisions saw medicine prices rise significantly faster than those that did not. During COVID-19, the patent choices of a handful of high income countries determined the vaccination timeline for the entire developing world. These are not side effects. They are the predictable structural consequences of treating IP as a domestic matter in a world where IP is simply not. The only coherent response is a cooperative framework that aligns domestic IP with shared obligations. Our second contention is that international cooperation in IP is not a proposal, it is not an experiment, it is the existing global order. The Paris Convention dates back to 1883, the Berne Convention to 86, and TRIPS was entered into force in 1995. WIPO administers over 26 international treaties today. The Paris Convention established national treatment and right of priority. The Berne Convention created automatic cross-border copyright protection, and TRIPS built further on this with Article 7, Articles 8, that IP protection should serve technology transfer and social welfare. The motion does not ask states to do something new. It only asks them to take seriously what they've already agreed to. And when states do this, it has delivered. The Doha Declaration, Article 31 bis, and the Marrakesh Treaty are all products of this cooperative framework. It is a system that works when used. And the proposition case is that simply it should be. Our third and final contention is that domestic IP supremacy would produce hoarding, it would produce trade conflict and hostile pricing. Because when IP regimes operate without cooperative constraints, the structural incentive for states and firms is monopoly maximization. And history shows us precisely what that would produce. Before the TRIPS framework existed, pharmaceutical companies routinely refused to license life-saving medicines at affordable prices. And with no multilateral mechanism to compel them otherwise, it took the Doha Declaration to reinterpret the global IP rules in favor of the public health. When cooperation norms weaken, disputes will escalate. The UNHRC analysis confirms that stronger unilateral IP rules undermine the right to health, precisely when states are not required to preserve TRIPS flexibilities. The choice before this House is therefore not between cooperation and sovereignty, it is between system with guardrails and one without. And the evidence tells us clearly what the latter produces. So, honorable adjudicators, the proposition's case is built on law, it is built on logic, and it has been built on lived reality. And for all these three contentions, the proposition is proud to affirm that national intellectual property regimes should operate in accordance with the international cooperation obligations. Thank you so much for giving me the time to speak.
Thank you for your opening statements. We'll now proceed to hear the opening statements for the against position by JSW School of Law. You have 4 minutes.
Am I audible and am I visible now?
You are.
Then I shall begin my opening statement in 3, 2, and 1. Esteemed judges and respected opposition, there are 190 plus states, each with its own different legal traditions and different national interests. Imposing a single global template on intellectual property laws is detrimental and ignorant of real national differences. Therefore, we oppose the motion. For this, we have 3 points. Number one, state sovereignty. Second, differentiated implementation. And third, violation of indigenous rights. 1. Constitutional supremacy and state sovereignty cannot be undermined in the name of upholding the duty to cooperate with international cooperation obligations. The duty to the sovereign equality of member states is enshrined in Article 2.1 of the United Nations Charter. Accompanying this, Article 31.3c of the Vienna Convention on the Law of Treaties encapsulates that treaty interpretation should be inclusive of all other relevant laws of international law applicable in the relations between the parties. Going by this understanding, imposing a strict conformity regime on international IP is detrimental towards acknowledging the state's inherent sovereignty and constitutional supremacy. This is especially apparent in states that follow a dualist political structure where treaties are not self-executing and require domestic approval. Additionally, when the legislation contradicts with other domestic legislation, the constitutional supremacy must be upheld. So, therefore, states are not legally obliged to comply beyond the minimum obligations. Moving to my second point, international law itself has inbuilt flexibilities within the IP agreements and regimes. For example, Article 31 of the VCLT encapsulates that treaty interpretation should be according to the ordinary purpose, context, and wording of the treaty itself. Going by this, Article 1.1 of the TRIPS Agreement has said that the states are allowed to come up with the most appropriate method to implement the treaty's provisions and ensure that they comply with the treaty's obligations. Nowhere is it said that there needs to be a strict conformity or uniform laws. Article 8.1 of the TRIPS Agreement goes further and states that states are allowed to adopt as well as amend laws to protect national interests, socio-economic interests, technological interests, as long as they comply with the agreement's main provisions. One such example is compulsory licensing. In 2007, Brazil issued compulsory licensing for the HIV drug efavirenz, patented by the Merck & Co. company, reducing prices by nearly 60% and saving countless precious lives. This would not have been possible if the agreement itself was a strict conformity-based one. Third, violation of indigenous rights. International IP regimes are focused around concepts of identifying a single inventor or a small group of inventors being granted exclusive rights. In contrast, indigenous knowledge is often communally held, intergenerationally passed down, and does not have an inventor in the Western sense. Therefore, many such indigenous knowledge have not received their exclusive rights despite being part of prior art as well. For example, in the John Bullen case from the Australian Federal Court, John Bullen was not granted his communal copyright, but was only granted his individual copyright. All of this points down to the fact that due to these differing state needs and sui generis areas of law, states need domestic legislative autonomy and not a one-size-fits-all approach. Therefore, we oppose the motion. Thank you.
Thank you very much for the opening statements. We'll now proceed to hear the rebuttals, starting with the first rebuttal of Jindal Global University. You have 2 minutes.
Good afternoon, honorable adjudicators and my very worthy opponents. Am I audible?
You are.
I will begin at the reverse countdown of 3, 2, 1. I will establish that operating in accordance with international cooperation is a binding moral and constitutional necessity. The opposition treats intellectual property as a private fortress of the state. But we argue that IP is a regulatory tool, that it must serve a social function. When a state's IP regime ignores this, it violates the fundamental human rights of those outside its borders. Imagine a village in a drought. One resident digs a deeper well, walls it off, invokes sovereign property rights, and charges inaffordable prices. In a vacuum, that is their right. But in a village where everyone's survival depends on that water, that wall is a humanitarian crisis. A national IP regime that refuses to cooperate in that wall is that walled off well. International cooperation obligations found in Articles 55 and 56 of the UN Charter are the village's agreement to ensure the water of innovation reaches everyone. The opposition first speaker argued that cooperation is a choice. International law says otherwise. Article 2.1 of the ICESCR requires states to take steps through international assistance and cooperation to realize economic and social rights. National IP regimes have extraterritorial obligations to refrain from policies that impair the rights of persons outside their jurisdiction. If a wealthy nation enforces patent protection so stringently that it stops developing nations from accessing life saving vaccines, it is in direct violation of its UN Charter duties. We agree that there's also the constitutionalization of IP law. But by international proportionality principles, national courts must find a fair balance between property rights of innovators and universal right to health. For example, by negotiating voluntary licenses, the MPP delivered 27 billion doses of HIV treatment to 148 countries, reducing costs from $10,000 to $70 per year. And let's talk about compulsory licensing. When Gilead launched their drug at $1,000 per pill, Malaysia exercised its right, which is an international cooperative legal mechanism under TRIPS, dropping the price from $12,000 to $300. Thus, we are proud to oppose.
Thank you. Now for the rebuttal by the JSW School of Law. You have 2 minutes.
Am I audible and visible?
You are.
Thank you. Good afternoon, everybody. I will begin in 3, 2, 1. Honorable judges, the opposition's arguments, while commendable, holds little merit and therefore there is no point in addressing all of them. Therefore, I have 3 rebuttals. First, the whole notion assumed by the proposition that the IP structure in international law is this global network of cooperation is entirely false. There may be individual and limited instances where nations cooperate with each other to defeat things like piracy, but in the vast majority of instances, IP treaties themselves fall within the domain administering their intellectual property law. Where national interests override these obligations, the clearest example is morality exceptions to every single type of registration. If one country is able to dictate to another what it should and shouldn't do in spite of their social mores, that is the antithesis of international law. Second, the proposition has brought up patents in their argument. However, the territorial nature of patent law is perhaps the most honest structural feature of the entire international IP system. If you want worldwide protection, you must file country by country, submitting to each jurisdiction's own rules, standards, and moral judgments. Patents are not globally instruments, they are fundamentally local ones, reflection of the fact that each state retains sovereign authority over their own borders. And lastly, the proposition's motion supports the restriction of publicly available resources as evidenced by the limiting of the public domain. The public domain is the very foundation of cultural, educational, and scientific progress. The Berne Convention initially required 50 years after death, but the US has considerably influenced the extension by requiring member countries to push to 70 plus years in the Trans Pacific Partnership Agreement. And as per research published in the Journal of Artificial Societies, the extension of the copyright term hinders scholars in producing new knowledge. Therefore, we reaffirm our position and rest our rebuttals. Thank you.
Thank you. We'll now hear the second rebuttal for the against position. OP Jindal Global University, you have 2 minutes.
Once again, a very good afternoon to the honorable adjudicators and my very worthy opponents. Am I audible?
You are.
I will begin at the reverse countdown of 3, 2, 1. The opposition views IP as a private fortress where you hoard the flame, but it is in fact a global relay race. In a relay, you have an obligation to pass the torch so the whole team finishes. If you hold on to the torch to keep yourself warm, the race and the team fails. The opposition claims that cooperation is limited and individual. But the absence of international cooperation obligations is what enables hegemony. Without reliance on WTO and WIPO frameworks, the world sees the special 301 process. When a country like India or Thailand is bullied for using lawful flexibilities, it is due to the abuse of unilateral power, filling the vacuum left by weak cooperation norms, not the law. This is a classic case of lack of cooperation. By operating in accordance with international obligations, smaller states move the fight from a dark alley of might makes right into a lit courtroom where the rule of law standards protect them. The opposition also argues that cooperation is essentially a one way street. We agree that current implementation has had flaws at some points, but the solution is not to abandon cooperation entirely. It is to demand that there is a fulfillment of the contract. By making operating in accordance with cooperation one of the central pillars of national law, Article 66.2 of the TRIPS agreement becomes a hard requirement for technology transfer. Law is a tool. A knife in the hands of a murderer does not negate its uses in the hands of a chef. International law is a floor, not a ceiling. Unfettered domestic supremacy over IP allows bad actors to exploit the jurisdictional gaps and hoard breakthroughs. The way forward is a multilateralism of equilibrium, a system that respects developmental needs while ensuring that global public goods are shared. We have to build a sturdier collective elevator that ensures every nation, regardless of starting points, can reach the floor of innovation and health and finish this relay. And for therefore, this house needs to stand for a world where knowledge is a bridge. It's not a barrier. Thank you.
Thank you. We'll now proceed to hear the second rebuttal for the against position by JSW School of Law. You have 2 minutes.
Then I shall begin my rebuttal in 3, 2, and 1. Respected judges, the opposition is of the belief that strict conformity to international IP regimes is required in order to solve global issues and in order to make sure that states abide by their treaty obligations. However, this is unfounded. Well, while states are required to while states are required to adhere to their treaty obligations under the Pacta Sunt Servanda of the VCLT, they fail to recognize that good faith performance requires contextual interpretation under Article 31 of the VCLT. Moreover, the TRIPS agreement, Article 1.1, sets only minimum standards, allowing states the discretion to implement obligations according to important domestic needs. This shows that international cooperation does not require rigid conformity, but allows states to retain flexibility. Also, the proposition has also supported that publicly available resources become more accessible when the IP regimes become more cooperated and adhere to rigid conformity standards. However, this is unfounded as well, evidenced by the very case of India itself. In India, decades ago, pharmaceutical products had little patent protection. As a result, they were able to provide cheap alternative generic medicines for a wide range of patients and help them to acquire these medicines at a cheap price. However, in the name of IP cooperation, states like the US pushed for IP branding and thereby reduced the access of these medicines. Therefore, whatever points the opposition has made are completely unfounded. We do not support their points at all. I rest my rebuttal here. Thank you.
Thank you. We are now proceeding to hear the concluding statements, starting with OP Jindal Global University. You have 2 minutes.
Good afternoon, honorable judges and colleagues from the opposing side. I hope I'm audible.
Yes, you are.
I will commence at the reverse countdown of 3, 2, 1. I rise to close for the proposition. I will show how the three contentions established by us prevail over the opposition's case. I will also briefly flag how our rebuttal successfully neutralized their principal objections. To begin with, this debate ultimately turns on a single organizing question. In a world of transnational globalization, can we still be governed as if consequences stop at the border? Our answer is no for the following reasons. First, on the factual structure of the modern IP economy, we established that intellectual property produces cross-border effects as a matter of design. The opposition repeatedly invoked sovereignty, but they did not displace a mechanism. Excuse me. Second, we demonstrated that international coordination is not a new burden being imposed on domestic law. It is the architecture the system already runs on binding instruments. The opposition attempted to paint cooperation as overreach, yet they never seriously contested that the global IP order is cooperative by design. Nor did they answer the concrete examples we gave of that system delivering workable outcomes in public health and access. Third, on what happens when domestic IP supremacy is permitted to override cooperative constraints. We showed the predictable end state through a documented pattern struck by hoarding, hostile pricing, and legal conflict. The opposition argued vulnerability to indigenous knowledge systems. However, on the contrary, cooperative obligations safeguard these developing nations from the harsh geopolitical realities and asymmetries. So, when you weigh this debate, three things follow. One, the opposition never defeated the empirical reality that IP crosses borders. Two, they never overturned the legal proposition that cooperation already structures IP governance. And three, they never outweighed the systemic harms that follow when exclusivity operates without cooperative alignment. And for those reasons, the proposition stands affirmed. Thank you.
Thank you. Now to hear the concluding statements for the against position, JSW School of Law, you have 2 minutes.
Am I audible and visible?
You are.
I will be starting in 3, 2, 1. Honorable judges and respected opposition, we live in a world of over 190 countries, each with its own history, culture, and legal system. To impose one single global template on IP law is not just impractical, it is fundamentally wrong. So we stand against this motion for 3 powerful truths: sovereignty, flexibility, and justice. First, international IP cooperation cannot override state sovereignty or domestic constitutional authority. Under the principles of sovereign equality, treaties require domestic approval and cannot displace conflicting constitutional laws, especially in dualist states. And second, international IP frameworks set minimum standards and permit states to adapt implementation to their own legal, economic, and social conditions as stated in Article 8.1 of the TRIPS Agreement. This flexibility enables measures like public health protections, such as when Brazil issued a compulsory license for the HIV drug efavirenz, demonstrating that strict cooperation requirements could undermine domestic welfare priorities. And third, global IP systems emphasize individual ownership, which conflicts with the collective and intergenerational nature of indigenous knowledge. Also, this has enabled biopiracy and inadequate recognition of traditional knowledge, highlighting the structural limitations of international IP law. So, esteemed judges, the choice is clear. Will we enforce a global IP regime that chokes sovereignty, strangles flexibility, and robs communities of their heritage, all in the name of so called cooperation? We say no. True cooperation does not mean blind compliance. True cooperation respects national sovereignty, allows life saving flexibility, and upholds justice. And let us be absolutely clear: intellectual property law should protect knowledge and not enslave nations. And true cooperation must never come at the cost of justice. Thank you.
Thank you. Thank you to both teams for your concluding statements. You can all now relax. You're no longer graded after this part. As is per the rules, the judges have 2 working days to observe your match and to submit the scoring cards. I believe they will have quite a challenge, perhaps already on the first day at hand, but really well done for the 2 teams, and thank you to the judges as well. Already now we have an opportunity to do a small feedback session amongst yourselves. So on that note, I would like to invite the OP Jindal Global University student, Mr. Shrirash, on with the question, how did you find the debate today? And perhaps did you hear familiar arguments from the opposing side?
Hello, am I audible?
Yes, you are.
Yes, so the debate topic, of course, is of high relevance. So I've worked with this topic before in my coursework as well. And while preparing, since we were asked to prepare for both sides, definitely we came across certain points that the opposition also made, especially about sovereignty and indigenousness. So definitely it was a very enriching experience experience. They also brought up a lot of points that we did not expect when we thought of it. So that was a whole new lens to look at this whole matter. So thank you so much for having us here. Thank you so much to the opponent team for enlightening us today. Thank you.
For sharing. Ms. Yangdon of JSW School of Law, same question.
Hello, am I audible?
Yes, sir.
Um, Thank you very much for the question. So to share my experience, our team has also like put a lot of effort towards this topic, and it has been a very enriching experience, especially since like we did not really study intellectual property law previously in our courses. So it was a new, like I would say, vessel of knowledge that we had to fill up, and it was very fruitful. And I am like very surprised at like how amazing the opposing team is as well. Like it was an absolute honor to compete with you guys and to be a part of this amazing competition. Thank you very much for like being this amazing part of my academic journey. I'm sure I'll remember this match very fondly.
Thank you, Ms. Yangdon. Ms. My apologies, Bhargav. Same question to you. How did you find the debate today?
I hope I'm audible.
You are.
Thank you so much, first of all, to the organizers for this wonderful opportunity. The topic itself was so engaging. We had a wonderful time prepping for both sides. That being said, I would say the pleasure is likewise. It was such a joy to listen to the dispositions of the opposing team as well. And as a matter of fact, they brought upon such fresh perspectives on the topic, which we did not think of while we were preparing. And in some, we too will reflect back on this match very fondly. So that would be my bit. Thank you.
Thank you. Thank you for sharing. From JSW School of Law, Ms. Dema, how did you find today's debate?
Udit has already responded.
Yes, so Ms. Yangdon.
So
Or perhaps Ms. Ladin.
we really apologize for that first. So yes, we did come across a lot of points that we have worked on as well, and I found that very interesting, and it was a very fruitful match for us. And like my senior mentioned, we none of us have studied IP law as of now, and it was quite a challenge at first, but then now that we have got the hang of it, it was a very amazing match for us. So thank you.
It's all right. All's good. Glad you have enjoyed the topic. From OPG Jindal Global University, Ms. Sarkar, how was the debate for you today?
Am I audible?
Yes, you are.
So firstly, I would like to thank the organizers for organizing this debate. I think the process of working on this debate just throughout the friendly matches and whenever we get a topic, it's something that all of us have started to really look forward to look at a new topic, to devise how to look at it from both sides and how to rebut our points that we ourselves have come up with. And that is something that I found personally very, very, very riveting. Um, Also, thank you so much to our opponents. The debate was amazing. I think I think there were a lot of points they did bring up that we ourselves had not found in our research. So to be able to counter that on the spot, that was quite a difficult task. But thank you so much, and yeah, that's it. Thank you.
Thank you for sharing. From JSW School of Law, Ms. Ladin, how was the debate for you today? Oh, you're muted.
We really apologize for that. I think I'll have Miss Hutton come here because her mute button is not working.
That's all right.
Hello, am I visible now?
Yes.
We're very sorry for the technical difficulties. This is our first time experiencing this kind of setup, so but to share my experience, I found this topic very intellectually stimulating, not only because of the fact that it was something that we hadn't learned about before, but we had to research and form arguments for both sides. So I think a lot of people, our friends, also sympathized with us on that fact because we only had 1 week to prepare for both arguments. But I think that me and my teammates, we were able to do well enough with the support of our coach advisors as well. And then I think that our opponents, they brought up a lot of very good points that I think we might not have thought of as well. So that was very interesting to encounter. So I'm very grateful to have been a part of this. Thank you.
Thank you. And really, all the congratulations from the organizing team for your first debate. You have done well for both teams. Your credits to your universities and to your law schools. On the side of organizing team, it's always a pleasure to see the first match and also to be able to witness up until your last match of the competition. You will find your rhythms. And perhaps already to learn a bit more with your teams, you have experienced how it is to debate amongst yourselves, but also a little bit of networking at the end of the session. So passing the floor to Professor Levanch to wrap us up.
Yes, congratulations. That was a great first match. I have to say, well done for everything you have already done. And obviously, during the next days will be the results and then the second match. So you will continue to let's say get more experience into that competition. Now, networking, because we want to know more about you, about your university, your city, and what to know as well, what to experience the first time we would come, maybe to visit your institution or your city. So I will have 2 questions for each team. You can answer as a team. You can choose who want to answer in your team. So these 2 questions, one is about your motivation. So what did you make, let's say, deciding to participate to this competition? How do you feel to represent your university in this competition? And the second set of questions is more on if the opposing team would visit for the first time your country, your city, what would be the first thing to visit, to know, to learn from your city, maybe university as well. So I will start with OP Jindal Global University. So who wants to answer these 2 questions? The motivation and as well the identity of your city and your university.
Good afternoon. I hope I'm audible.
Yeah, you are.
So, motivation for my team and personally myself as well. We were all, before we engaged with intellectual property law in our coursework, we were quite the enthusiasts, and accordingly, we got inducted into the Jindal International Law Society here as well. We also saw Rishabh participate last year, which also was primarily the reason why we were also equally eager to take part in Corax. And as far as our university goes, I think the one thing that all of us are increasingly proud of is the newly inaugurated arbitration negotiation moot court auditorium, which has been built in our campus. And it provides an amazing platform for us to engage in all kinds of discourses, to host all kinds of discussions, competitions, and accordingly, we also get to interact and meet such wonderful individuals, much as yourselves, while taking part in those competitions. So that would be our 2 points we would like to.
Thank you. I don't know if your colleagues wants to add something.
I think Sarah. Sorry, apologies. I think Sarah covered most of what we wanted to say, but again, thank you for the opportunity. And yes, I think we're all international law enthusiasts who have come together with because of our passion for this. Thank you.
Thank you very much. Same question now for the team from Bhutan. So what made you proud, let's say, to present university, to participate for the first time? So who wants to answer? Yeah.
Hello once again. To answer your question, so first of all, what motivated us? Well, I would say that we have got the most amazing team advisors that we could have ever wished for this competition. They are one of the best students who have like studied law and like have so much experience and so much love and care for all 3 of us. Like, it has been a very special experience, not only because it is academically enriching, but additionally because like it makes you like remind yourself that there is love everywhere, and that there will always be people who will be ready to support you and see you grow and become your best version. So this has been our motivation. Our institution highly values academic excellence as well as discipline, respect towards different cultures, and I think that this is just one of those competitions where we get to learn and uphold all 3 of these. So this is what we are proud of and what has motivated us so far.
Thank you very much. So it was great to hear, and we want to tell you that as well, this competition is a reason for networking. So you never know in your career. I know that Bhutan and India are not far from each other, but through the competition we meet universities from many places around the world. So you never know in your career if you will need to contact an expert about another country, another jurisdiction. So through this competition, do not hesitate to keep contact, to see if you want to get, I would say on the long term, maybe in connections for your career, for being friends maybe, and that will be useful, you will see later. So I would like to thank both teams, both team of coach as well, because I know that you are supported as well by experts on this competition and international law in general. So many thanks for this first match. That was a pleasure for us to have you starting this match today and doing the next day. So it means next week, early next week, we hope. The 3 judges that we send greetings to, they will be sending us the results, and we will share with you the score sheets for each team, what each of the 3 judges have said for each team, and we hope that this will help you as well for the next parts of the competition. So many thanks, and we keep in touch, and yes, you will hear from us, and looking forward to see you in the day 2 match of the group phase in around 2 weeks from now. So many thanks in India, in Bhutan, and we keep in touch. Thank you. Bye-bye.
Well done, everyone. Goodbye.
Bye.
Thank you.